a real powerful and practical report. I also want to thank everyone who joined us at the report launch that we had in Annapolis. It was last month, and that event, if you were there, I think you'd agree, showed the strength that we have as a diverse coalition in so many different ways, and represented in government, academia, advocacy, and community groups. The energy in the room, I think, made it very clear that together we can drive real change. And the work of the collaborative didn't stop just with the launch of the report in terms of what was happening in Annapolis, because many of you were on the front lines advocating, engaging, and pushing hard during the 2025 legislative session. And thanks to your effort, we passed key legislation to expand medical and geriatric parole. Also passing the Second Look Act, and many of you involved much longer than I certainly have been. And as many of us know, when big things in Annapolis get done, it often takes a really long time to get it done. So your persistence, your tenacity, your commitment and passion, we got it done. And that gives people a real chance now at meaningful review and release from incarceration. So these wins certainly will help reduce racial disparities and promote rehabilitation in our prison system. There's still so much more to do. That we see it in the recommendations that we put forward. And there are more good, important, relevant, pertinent, urgent issues that so many of you have been working on in addition to those 18. But certainly what we did this legislative session, what we put forward in the report, it shows progress and suggests strongly that what we can do and what we can accomplish together. So I'm going to turn it over to my incredible co-chair, my partner, Natasha Dartigue, who will take it from here and share more about the report.
Thank you so much, AG Brown. And hello, distinguished collaborative members. Thank you. I really want to express my great appreciation for all the work that has been done so far, and I echo everything that AG Brown stated. I did want to give us some perspective, because us meeting today does have historical connotations, and I came to learn this, and I say a great thank you to Kirsten Downs, because I came to learn the real significance of what is known today as Easter Monday through Kirsten. So thank you. And I thought it was important for us to share, since we are meeting on Easter Monday. And essentially, I'll give you the context, and you'll see how it all comes together with the fact that the collaborative is meeting today. So so this is essentially a brief history of Easter Monday for those of you who celebrate the Easter celebration. So Black families would gather at Washington's National Zoo for Easter Monday celebrations, and that dated back to 1936. And Easter Monday traditionally falls on the Monday after Easter Sunday, but for African Americans, that is more than just an ordinary Monday, because historically, our communities had claimed this day as one of rest, reflection, resistance, and celebration. Because in the late 19th century, when segregation barred Black children from the White House's Easter egg roll, and that was a tradition that was first held in 1878, Black families in Washington, D.C. created their own Easter tradition, which circled around the National Zoo. So beginning back in 1891, Black domestic workers who had often spent their Easter Sundays serving white households brought their own children to the zoo on the Monday to celebrate together. They held picnics, played music, and organized Easter egg hunts of their own. And the gathering grew into a massive annual event. In 1919, nearly 55,000 Black people filled the National Zoo in this joyous fellowship. Easter Monday became an unofficial Black holiday, a day Black communities could call their own across generations. And it was a day when Black families who were traditionally shut out from white society celebrations turned exclusion into togetherness and into joy, and became a yearly family reunion born from resistance. So the history of Easter Monday stands as a powerful testament to Black resilience and liberation. So this simple act of gathering on Easter Monday was an expression of freedom and dignity. So today, as we talk about in the face of mass incarceration and the over-incarceration of Black people, we think about that same energy that Easter Monday brings forward. We think about the Black ancestors who turned a day of exclusion into celebration of community. And we now claim this as a day to renew our commitment to the justice that we fight for, especially those who have brothers, sisters, and children behind bars. So as we gather today on Easter Monday, I hope that you're reminded that after pain comes renewal. And just as we celebrate Easter, and those, even if you don't celebrate Easter, it is a reminder that we can stand together and be unified, and that even when we see things as difficult or hard or oppressive, that we can transform them and do so in community. So that is a bit of a historical perspective on Easter Monday, and how that is really significant that we gather today as we are entering our next phase of the work that we would do together. Because it is through your diligence, your advocacy, and your pursuit of justice that we were able to really create this impressive foundation that we are going to build our future work on. So for those who may have missed the report reveal, here's a brief and very brief glimpse of what that event looked like. So Christian, you can hit play for me. Hopefully we've got it queued up. Uh-oh, but we're
Is it
hearing
working?
can you restart it? I don't hear it though.
Okay, I mean. Try this. All right, let's see if this should. Does that work?
We can see it.
Can't hear it?
No, but that's okay.
There's when you share your screen, there's a little box on the right that says share sound that you have to click in order for the sound to play when you.
Okay, let me try that again.
It'll
I'll
also
try.
say optimize for video sharing. You want to
Yeah.
do the video sharing and the sound.
All right. See, now it's gonna be anticlimactic.
All right, we tried to share sound. Let's see.
Oh, there we go. Okay, so like I said, a brief glimpse into what was really a very, very successful event. We had a full house, an opportunity to engage with one another. Hopefully, each of you have received your own personal copy of the report that really reflects all the hard work that you have put in. If you didn't, please reach out to Christian, and he'll make sure that you get a copy. But at the very least, you should have received the link that took you to the report. That is really a comprehensive assessment of our criminal legal practices here in Maryland, and it really revealed a lot of the stark disparities that we know demand immediate action. It really speaks about the disproportionate impact on our Black and Brown communities. So I challenge you today, as we talk about where we go from here, to have the same fervor that you did when we came together back in October of 2023. And you think about all the work that was put in these past several months, because we're going to need the same zeal so that we can facilitate the implementation of our MEJC recommendations. And with that, I will turn it back over to Christian and Kirsten.
Good afternoon, everyone. I'm honored to follow those powerful words and just highlight a little bit of our progress that we made during this recent legislative session. But before I speak, I want to introduce the Honorable Judge Karoum, who will address the implementation of the geriatric and medical parole. And then Brian Sesente, Chief of the Maryland Office of Public Defender's De-Incarceration Project, will discuss the Second Look Act. So I'll give Judge Karoum.
Thank you. So here is what I hope is a really quick summary of the geriatric medical parole bill. It was proposed back in 2015 and 16 by the Justice Reinvestment Coordinating Council that Maryland should expand our use of geriatric and medical parole. And there was legislation back in 2016 that attempted to do that, but there were a couple of errors in that legislation that resulted in our parole rate for geriatric and medical lagging behind sister states. Our rate was like 25% in comparison to other states, which was like 40% of those eligible. It was racially disparate. The number of people affected, I think, was probably more than 71%, especially in the geriatric category. And this led to excessive taxpayer expenses. So one of the errors in drafting was that when the governor was taken out of the parole system as to people serving life, we did not get the statute as to geriatric or medical parole. Actually, it's a medical parole changed. So the governor was still required to sign off on every single medical parole. The proposal is that in the bill that was just approved and hopefully will be signed by the governor tomorrow, would fix that. And it also improves language as to geriatric parole. In the geriatric, it was mistakenly put in the criminal law article, and it was written in a way that appeared to make it apply only to people who were serving a second violent crime conviction. Since that is a much smaller group than the entire population, the statute that was passed this session was needed to expand it. Now it potentially applies to anyone who is 65 years old, who's served at least 20 years of a sentence. It can't be life without parole. It can't be registered sex offender. It can't be someone who's had a 1A infraction. I think that's a serious assault in the prison system within 3 years. Other provisions are that the parole commission may order a risk assessment, but otherwise, if there's someone eligible, 65, they've served 20 years, they should hear the case ASAP. They're allowed to have only one such hearing every 5 years unless there are extraordinary compelling circumstances. The medical provisions that were adopted, again, this is for anyone not limited to the population of geriatric, includes people who are chronically debilitated or incapacitated, who have a terminal illness. In other words, their doctor says they're likely to die within 6 months, or they require extended medical management that would be better done in the community than in prison. This medical management issue means that uh, they may be physically incapable of presenting a danger to society due to physical or mental health or some syndrome. One of the points of negotiation in this bill was that they wanted to make sure that someone who was applying for release had the treatment available in the community, had housing available in the community, whether it was with the family or in hospice or in a hospital. And they also provided that the parole agent, parole or probation agent had to be able to confirm these things. And the last major point of discussion that was involved with amendments in both House and the Senate side was that they wanted to provide that if someone recovered, made a miraculous recovery from a medical condition so that they were no longer chronically disabled or they were cured of their terminal illness, that they could be required to return to custody or at least to have another hearing. The results of this, we think, will impact about 1,000 people who are incarcerated, who are age 65 and have served 20 years. And it would also impact a large number of people, we don't know the exact number, with these medical conditions. So there should be a lot of taxpayer savings. The savings are going to be used to pay for the cost of the parole process, psychologist fees, risk assessments. They would also use savings to pay for more pre-release and reentry management services. And finally, if there are funds after those things are paid for, it would be put into the Justice Reinvestment Performance Incentive Grant Fund, which is again a fund from which local government can obtain grants that help to reduce crime and provide alternatives to incarceration. And that is all I have to say about that, unless anyone has questions. I would just add maybe is a wonderful thing that our leaders of the Equitable Justice Collaborative appeared in person, shoulder to shoulder, the Attorney General and the Public Defender, to testify for this bill. And that was very helpful. It's also been very helpful that the chairs of the Parole Commission, currently Chairman Ely and previously Chairman Bloomberg, also actively supported this bill. And again, it's a win-win in the sense that it reduces the prison population, reduces racial disparities, saves taxpayer funds, and is no danger to public safety because it is very good policy.
Thank you, Judge Karim. Brian?
Hi, everyone. Good afternoon. So House Bill 853, known as the Maryland Second Look Act, was passed by the General Assembly on April 3rd, 2025. It's now on the governor's desk for review. In its final form, the act expanded the sentence review provision created by the Juvenile Restoration Act to allow emerging adults, that is, people who were at least 18 but not yet 25 years of age at the time of the crime, to file a motion for reduction of sentence after they've been incarcerated for at least 20 years. The sentence review provision for emerging adults, however, unlike for juveniles, excludes certain groups, including people who are designated as sex offenders under Maryland law, people convicted of murdering a first responder in the line of duty, and people serving sentences of life in prison without the possibility of parole. After a motion is filed, a circuit court is required to hold a hearing where the individual who filed the motion and the state may present evidence. There are a number of protections for victims or victims' representatives. In the statute, a victim or victim's representative has the right to notice of the hearing, to attend the hearing, and to present a victim impact statement. The statute provides that the victim may not be cross-examined on their victim impact statement, If the movant is released, if the individual filing the motion is released, the judge is required to issue a no contact order as a condition of any probation unless the victim requests otherwise. And the judge also may impose any other condition necessary to promote victim safety and peace of mind. Judges may not grant relief under this statute unless they determine, one, that the individual is not a danger to the public, and two, that the interests of justice will be better served by a reduced sentence. Like the Juvenile Restoration Act, the statute continues to provide that if the court denies a motion or grants it only in part, an individual can file a second and, if necessary, a third motion after waiting at least 3 years from the previous ruling. After 3, the person's done, a person may not file a fourth motion. If the governor signs the bill or allows it to become law without his signature, the Second Look Act would take effect October 1st, 2025. And like Judge Groom, I'm happy to answer any questions if anyone has any about the act. Thank you.
Any questions? Okay, I wanted to highlight just one more bill that we had less of a influence on, but is still significant to the priorities and the recommendations in the MEJC report, and that's the passage of SB 68 and HB 197, which directs the Maryland Department of Education to create a detailed plan providing implementation tools for school districts interested in adopting restorative practices. So this bill now defines restorative practices as culturally and communally responsive, relationship-focused rather than punishment-driven, centered on repairing harm, restoring trust, and promoting accountability, not exclusion. They encompass additionally peer mediation, restorative circles, trauma-informed care, and social and emotional learning. Importantly, the Department of Education is required to assist schools with technical support during this transition. This legislation directly aligns with the Workforce Education and Employment Workgroup's recommendation number 15, which emphasizes addressing the rising criminalization of in-school behavior with arrests and the need to enhance implicit bias training, as well as revisions to the discipline and criminal justice policies within our public schools. This legislation confronts one of the most deeply rooted harmful forms of systemic injustice, which is the disproportionate punishment of Black children in our schools. So although Maryland's Black students make up only 33% of the public school population, they account for over 56% of the school-based arrests. So focusing on restorative justice practices in schools can disrupt this crucial first stage contact with the criminal justice system. So we continue this one as a win. We definitely had a few more bills that we promoted through the MEJC efforts. Some, of course, weren't as successful, but I think what we were successful is making our presence known with regard to the issues that are priority for the MEJC. We will continue to work on those bills. Many of the bills that did pass were going on for years and years, and so it's not necessarily a one-shot deal. And so we have to keep the fight up and advocate for these changes that will get us closer to our goal of reducing over-incarceration. Thank you. And if there's any questions or comments.
Any questions, comments, or, observations, feedback from the legislative session on any one of those 3 bills or any other? Certainly want to invite folks to weigh in and share their observations and assessment and things like that.
Just a question for clarity. Was the restorative justice bill signed? Has that been signed?
No. All of the bills are scheduled for signing tomorrow. but we only have an unofficial list, so it still remains to be seen. The Attorney General and Public Defender have sent a letter to the governor supporting the signage of the Second Look Act, because I think that was the most controversial. But hopefully we'll have a definitive answer tomorrow.
Okay, thank you.
Any other questions or observations? All right, thank you.
Thank you, Kirsten. Next, we're going to discuss our strategy moving forward related to the recommendations and over the next year. So first, I want to thank everyone who completed the survey. It was very helpful, and we appreciate the range of activities that you're currently engaged in and the time you've been dedicated to this important work. And those survey responses were definitely instrumental in helping us shape our path forward. So the collaborative's primary focus for the next year was moving our recommendations from paper to practice. We're going to concentrate specifically on engaging key decision makers who have the authority to adopt our recommendations. The collaborative's role will be to facilitate this adoption process, creating pathways for implementation across our different systems. To that end, we're currently drafting an engagement plan that will detail the specific steps to convince decision makers to adopt our recommendations. The plan will identify the particular decision makers relevant to each recommendation. And again, we want to thank you all because again, most of that work was completed by the work groups when you identified stakeholders and other activities. It will also outline the particular engagement strategies and establish timelines. This plan will serve as our roadmap for translating the hard work that went to developing our 18 recommendations into concrete system changes. The leadership group, which again, for anybody who may be new, is the public defender, the attorney general, myself, Kirsten, Zanita, Keith, and other leadership, are also going to be taking the primary responsibility for executing the engagement plan. What that means is we will call upon the expertise and time of collaborative members to support specific engagement members and facilitate the implementation of recommendations based on your areas of knowledge and influence. Of course, your participation in these meetings with decision makers and helping to provide technical assistance in developing supporting materials for these connections with our key decision makers will be invaluable. Once the engagement plan is complete, we will share with all of you for feedback. Your insights will help us refine our approach and identify any opportunities or challenges we may have missed. This collaborative feedback process will also help strengthen our implementation strategy. Finally, regarding the work groups, we recognize and appreciate the ongoing work of our work groups. As we said, the priority moving forward will be the execution of the engagement plan. And as mentioned, collaborative members will play a key role in that work. That said, to the extent your work groups have additional capacity, you may, of course, continue developing additional recommendations, not including the initial 18. You may organize educational events or other outreach events, such as the Youth Justice Work Group's public event at Cheltenham Youth Detention Center that support the development of recommendations. Or you may choose to pause those activities and focus on your capacity on supporting our engagement with decision makers. We understand that different work groups have different resources and capacities, and we value contributions in whatever form works best for any circumstance. We'll be following up with the work group co-chairs to get a better understanding of any work planned on developing new recommendations or outreach activities, and also scheduling an executive work group meeting with our co-chairs to talk more in detail about the plan. Then that concludes my presentation. Are there any questions?
Any questions by show of hands, or is there anybody in the chat? Just to follow up on some of the things that Christian mentioned in terms of steps ahead. As he mentioned, leadership is going to develop an engagement plan, right? And we've laid so much foundation in the report, identifying stakeholders, identifying decision makers. For each recommendation, there's, implementation, I don't know what you'd call them, steps or phases or components that are certainly suggested to decision makers as they're implementing certain things to fulfill or adopt the recommendation. So along those implementation lines, we're going to develop an engagement plan so we can facilitate decision makers, I shouldn't say assuming, but after our efforts to get their buy-in, and then the things that we in the collaborative can do to facilitate the adoption by the decision maker of the recommendations. And as Christian mentioned, looking to collaborative members to participate in that engagement effort, or that in executing the engagement plan, because the goal is to do everything that we can as a collaborative to facilitate adoption of these recommendations by decision makers. Some of them, it's going to be a lengthy process, no doubt. It'll be challenging, no doubt. But that's what we envision as the next phase of the collaborative. Anybody have any questions, comments, thoughts?
I see Michael Pernard, Professor Pernard has his hand, raised his hand, I believe. Professor Pernard.
I'm sorry if I did not do anything to put my hand up, so I don't have any questions. I apologize. So
okay.
Right. Well, I want to thank the PD for explaining why my mother took me and my sisters and brothers to the zoo every Easter Monday. So that was first I heard of that. So thank the public defender for explaining that.
All right. If there are no questions or comments, we can move on to adjournment. Are there any general questions or comments at all before we move on to questions about our current status, anything? I don't think we have any. Madam PD, it's to you.
So thank you. I do want to highlight some things that the Second Look Act, as well as geriatric and medical parole, are slated for the governor's desk tomorrow. So if you are in the area of Annapolis or had the opportunity to get to Annapolis, bill signings, I think, started around noon. Would love to see you out in Annapolis for that event. It's going to be extremely exciting time. And it's going to be a fabulous day, I hear, tomorrow. So it's a good time to be down by the water. I also want to put in a plug for an event on April the 29th. It is supported by the Office of the Public Defender, but it speaks directly to reentry, and it's titled Starting Over, Reducing the Barriers to Women's Reentry in particular. As we know, women, especially Black women from disadvantaged communities, are the heart of the community and their families. So when we speak about women's reentry, that's a really important population. And that's going to take place on Tuesday, April the 29th at 6 p.m. at the Care First Blue Cross Village. And that is a new center in Mondawmin Mall, a beautiful facility that has different resources for the community. If you're familiar with Mondawmin Mall in Baltimore City, that's the area where the Target was. They've totally transformed that space and offer different resources to the community. So it's a great event and great opportunity to see the space and what is offered there. We talked about our recommendations today and our plans as to how we're going to facilitate these coming to life. And please make no mistake that these are going to require unprecedented coordination. It's going to require us to leverage our relationships with numerous state leaders, state agencies, relationships within the Office of the Public Defender, as well as relationships within the Office of the Attorney General. I say to you that our recommendations, and these are our recommendations, we are the Maryland Equitable Justice Collaborative, and that they are not merely aspirational goals, that these are actionable imperatives that fundamentally will reshape how Maryland treats Black and Brown people, but also really reshapes Maryland's justice system. The data is there that supports these initiatives, and the moral case is unassailable. And our moment for action is, in fact, now. The next phase of our work to actually breaking that 71% in Maryland starts today. So I hope that we proceed with the same force as we did when we came together. And I submit that we remain united in our purpose and unwavering in our determination, because we not only possess the capability, but it is our moral obligation to transform these words on paper into a reality. So I say thank you. I look forward to the great work that we're going to do ahead. And with that, I'll tap in AG Brown if he wants to add any additional closing comments.
No, I've been in partnership with you long enough to know that your closing words typically do it. And so thank you very much, Public Defender Dartique. Thanks to each and every one of you for, again, work you did leading up to where we are after about 18 months of working together. Thanks for joining us today. We will have our next quarterly meeting. What do we have a date for that, Christian? No, we're usually in what, 2 or 3 months?
Yeah, like 2 or 3 months, yes.
Right. And certainly the goal is to have to get to you before that, the engagement plan for your review. And then we can have conversations about that. And no doubt we'll be in touch with many of you between now and then as we solicit your ideas, your input, your thoughts, your feedback, etc. So thanks, everyone. Have a great week.
Thanks, everyone. Take care.
All right.
Bye, everybody.